Hello everyone. In this video, we are going to cover the last stage in the procedure relating to the child in conflict with law. In last video, we have understood the four stages or the steps involved in the procedure relating to the child in conflict with law. That is how the board can inquire and pass appropriate orders. So, in that, this is the last stage. So, Section 15 explains about preliminary assessment into heinous offences by the board. So, as we know that there are three kinds of offences, that is petty offence, serious offence and heinous offences. So, there is a different type of inquiry that shall be conducted by the board in cases of heinous offences. So, before conducting the inquiry, the board shall conduct a preliminary assessment of the child. So, section 15 explains how the assessment shall be conducted. So, the preliminary assessment shall apply to the children of the age 16 to 18 years is alleged to have committed a heinous offense. So, the Juvenile Justice Board conducts a preliminary assessment of the child's mental capacity, physical capacity to commit the offense, ability to understand the consequences of the offense, and circumstances in which the offense was committed. So, the assessment shall be conducted only to the children who have committed an heinous offense and who are between the age of 16 to 18. So, in that case only, a preliminary assessment of the child shall be conducted. The preliminary assessment includes the mental capacity of the child to commit the offense and physical capacity of the child to commit the offense, ability to understand the consequences and circumstances in which the offense was committed. So, if the child is below the age of 16 years and have committed a heinous offense, then there is no need to conduct a preliminary assessment. The inquiry shall go as if the juvenile have committed a serious offense. So, in that way, the inquiry shall be completed. So, it applies only to the children between the age of 16 to 18. So, by this assessment, the board can know whether the child is capable of understanding like as an adult or not. If the result is that the child can understand the consequences and know what happens by committing such a type of offense, then the board shall forward that case to the children's court to conduct an inquiry as an adult over that juvenile. So, depending on the preliminary assessment result, the child shall be investigated either in the Juvenile Justice Board or in the children's court. In cases of heinous offences, the board may take the assistance of experienced psychologists, psychosocial workers or other experts for the assessment. So, to conduct this assessment, the board may take the assistance of any of the experts. And where the board is satisfied on preliminary assessment that the matter should be disposed of by the board, then the board shall follow the procedure as far as may be for the trial in someone's case under the Code of Criminal Procedure 1973. So, after the assessment, the board comes to a conclusion that the child is not capable of understanding the consequences of what he have done, or he is not to be treated like an adult. Then, in that cases, the board will dispose of the case on its own by following the procedure laid down in the CRPC 1973. Provided that order of the board to dispose of the matter shall be appealable under subsection 2 of section 101. So, after preliminary assessment, if the board decides to dispose of the matter on its own, then that order can be appealed under subsection 2 of section 101 in any sessions court. So, if the board decides to dispose of the matter on its own, it can pass the orders under section 17 and 18 of the Juvenile Justice Act. Section 17 explains that if the child is not in conflict with law, so it is found after inquiry that the child is not in conflict with law, that the child has not committed any offense. So, in that cases, the board shall follow section 17. So, the board shall pass order to that effect. In case the child is in need of care and protection, the board shall refer the child to the committee. So either the board can pass an order, send back the child to home, or if he is in need of care and protection, then the child can be sent to the child welfare committee. So according to the condition, the board may pass appropriate orders. If the child is not found in conflict with law, then the board shall follow section 17. If the child is found to be in conflict with law, then section 18 shall be followed. So in the inquiry, the board came to a conclusion that the child have committed any offense. Then section 18 shall be followed. So according to section 18, if the Juvenile Justice Board after inquiry finds that a child of any age has committed a petty offense or serious offense, or a child below 16 years has committed a heinous offense, or a child above 16 years has committed a heinous offense, but the board has already completed the preliminary assessment under section 15 and disposed of the matter. So there are 4 scenarios in which under section 18 the board may pass orders. That is, in cases where a juvenile have committed either a petty offense, serious offense, and a heinous offense. In this, there are 2 kinds. Those children who have committed a heinous offense below the age of 16 years, and those children between the age of 16 to 18 who have committed a heinous offense. So, in these cases, a preliminary assessment is conducted. So, after inquiry have completed in these cases, that is the petty, serious and heinous offences, notwithstanding anything in other laws and considering the nature of the offense, the child's need for supervision, the social investigation report, and the child's past conduct, the board may send the child home after advice or admonition with counseling, direct child to attend group counseling or similar activities, order community service under supervision, ask child, parents, guardian to pay fine if capable, release the child on probation under care of parent, guardian, fit persons for a maximum period of 3 years with bond. So, according to the nature of the offense, that is, whether the offense is a petty offense or a serious offense, accordingly, the board may pass these orders. And it also includes release the child on probation under supervision of a fit facility, send the child to a special home for reformative services such as education, skill, counseling, therapy, psychiatric care. And if the child's conduct makes stay in special home unsafe, board may send the child to a place of safety. So, accordingly, basing on the nature of the offense and the child's conduct, the board may pass any of these orders. In addition to that, the board may also direct, along with clauses A to G, to direct the juvenile to attend school, attend vocational training, attend therapeutic center, prohibit visiting certain places, undergo a de-addiction program. So, in addition to these clauses, the board may also direct the juvenile to learn any of these skills and to attend any counseling sessions, etc. And if after preliminary assessment under section 15, board decides child above the age of 16 years needs to be tried, it may transfer the case to the children's court. So, as we have understood, basing on the report of the preliminary assessment, the juvenile shall be inquired either in the Juvenile Justice Board or the case may be transferred to the children's court. So, cases will be transferred to children's court in cases where the child is found that the juvenile is capable of thinking like an adult, then in that case, the juvenile will be sent to the children's court to be tried as an adult in the cases only of heinous offences. So now let us understand the powers of the children's court. So after preliminary assessment under section 15, the children's court has 2 options. If needed, the child may be tried as an adult under CRPC but with special care for fairness and child-friendly environment. If not needed, the court may conduct an inquiry like a Juvenile Justice Board and pass orders under section 18. So, after sending the case to the children's court has 2 options. That is, to conduct the trial of the child as an adult, but with special care and fairness, and in a child friendly environment. Or it may conduct the inquiry according to the Juvenile Justice Board. And the orders which are passed shall be according to Section 18. That is either sending the child to home or giving him counseling, training, or vocational courses, or any other orders according to Section shall be passed by the Children's Court. And the final order must include an individual care plan for rehabilitation and follow up by a probation officer or district child protection unit or a social worker. So the orders which are passed by the Children's Court must include an individual care plan for rehabilitation of the child, and it shall be followed up by any of these officers. And if the child is found guilty, the child will be kept in a place of safety till 21 years of age, and after 21, the person may be shifted to jail. During the place of safety, the child shall be provided with education, skill development, counseling and therapy, psychiatric support. So, if the child is found guilty, then he shall be kept in a place of safety until he attains the age of 21 years, and after that, he shall be shifted to a jail. And every year, a follow up report must be prepared by the probation officer or DCPU, that is the District Child Protection Unit, or social worker. And these yearly reports must be sent to the Children's Court for record and necessary action. So, these are the powers of the Children's Court. So, let us end the video with two more provisions. According to Section 21, a child cannot be given a death sentence or a life imprisonment without release under this Act or the IPC or any other law. So, either the board or the Children's Court or any other court cannot give a child a death sentence and also a life imprisonment without release. That is, a life imprisonment can be given to a child, but there shall be release of the child at a certain point of time by taking into consideration the behavior and the condition of the child and whether he have rehabilitated or not. According to those, the child can be released. And the next is no joint proceedings of child in conflict with law and person not a child. So, notwithstanding anything in the Code of Criminal Procedure 1973 or any other law, a child in conflict with law cannot be tried jointly with an adult, that is, a person who is not a child. If during the inquiry the board or the Children's Court finds that the person is not actually a child, that person will not be tried along with the child. So, a child cannot be jointly tried with an adult. So, a child is a person who is below the age of 18 years and an adult is above the age of 18 years. So, both persons cannot be tried jointly. Separate trial shall be conducted for an adult and a child. So, this is the procedure that shall be followed by the board or the Children's Court relating to the child in conflict with law. So, that's all in this video. I hope you all have understood it. Thank you.